Welcome everyone to our latest webinar, Filling the Gap, State Enforcement of Federal Environmental Laws. My name is Liz Klein. I am Deputy Director of the State Energy and Environmental Impact Center, and I want to thank you all for joining us today. In recognition that no one signs up for these things to listen to the moderator, I am going to move through my remarks quickly. First, I just wanted to give everybody a brief introduction to the center and what we do in case you're not familiar with our work. We support state attorneys general in pursuing their progressive clean energy, climate change, and environmental goals. And for those of you who have visited our website or receive our bi-weekly newsletter, and if you don't, go sign up. It's called Legally Speaking and helps chronicle the work, the important work and really unprecedented work of the state AGs in pushing back against this administration's really unprecedented deregulatory agenda. State AGs are also playing a really crucial role in filling the void left by many federal agencies in enforcement of our nation's environmental laws, which is what brings us here today. The center recently released a report called A Pass to Pollute, Environmental Non-Enforcement by the Trump administration. We've put the website link there for you to go and check it out in case you have not already seen it. It chronicles some of the actions that the administration has taken that indicate that they are not on the job, as it were, when it comes to enforcement of our nation's environmental laws. Data like EPA inspections and case initiations certainly down over the course of the past several years. The center is obviously not the only group reporting on these things, but certainly it's there's lots of indications out there that the administration is not taking a strong enforcement role when it comes to our environmental laws. But fortunately, state AGs, again, have been playing a crucial role, and they can and have been stepping up on enforcement issues. So today we are joined by two stars of the Massachusetts Attorney General Office. Many of you also know Attorney General Maura Healey has really been a true leader on all sorts of fronts, but certainly in the area of environmental enforcement, and her efforts, we think, can really serve as a potential model for other offices that are addressing similar issues. So I'm pleased to introduce our two panelists for the day. First is Nora Chorover, who's our Special Assistant Attorney General. She heads up the Environmental Protection Division's Federal Clean Water, Clean Air Enforcement Initiative in AG Healey's office. And she is joined today by Emily Mitchell, who is an attorney also working on that initiative in the Massachusetts AG office. And before I turn it over to them, just one brief programming note. I know it's hot where everybody is, and it's the afternoon on the East Coast anyway, but don't be shy or too tired to get your questions in. For our panelists today, we will leave plenty of time at the end for them to field questions that you may have about the important work that their office has been doing on environmental enforcement. And so with that, I will go ahead and turn it over to, oh, and I should say, when you have questions, the Q&A box, which I'm sure everybody is familiar with at this point on Zoom, you can go ahead and submit your questions there, and I will field them and present them at the end of the presentations. And so with that, I will turn it over to Nora.
Thank you, Liz. So, am I visible to people? I'm going to assume I am and go ahead. Hello, everybody. Thank you so much, Liz. And also, I want to thank the center for really making this project possible, being primarily responsible for getting this program off the ground. And what our message today is that the citizen suit provisions of these federal environmental laws, the citizen suit is a very powerful tool. And the attorneys general are uniquely situated to house these types of programs within their offices. And not the cases will benefit, and also the offices will benefit. We've done it. We have been putting this together for a couple of years now, and we're prepared to be a model and to assist other offices that may want to go this direction as well. So what are citizen suits? Probably many of you know they are lawsuits by private persons, including states. Statutorily, persons is statutorily defined to include states, that enforce statutes. Most federal environmental statutes do include citizen suit provisions, because when they were passed or shortly thereafter, Congress recognized that there would be times when the government would not, it would be often that the government would not get to everything, either because of a lack of resources or because of political considerations or what have you. So these provisions were put in there, and the need has always been there, but perhaps never as much as today, as has been shown with the recent report from the center, which showed that there have been 43% fewer investigations since in fiscal year 2019 as there were for the average of the Obama administration. So the need is there, and the results that can be accomplished through these types of cases are significant. You can obtain more widespread environmental compliance through general and specific deterrence, and also resources to enhance the environmental conditions at the location of or in the vicinity of the violations. There are certain prerequisites for bringing these types of cases, and those include standing. You have, most of you I'm sure know what that means. The one or more person within the organization or entity has to have an interest in the environmental area. You have to provide adequate notice. Notice provision is jurisdictional, so you can't mess it up. You have to follow the rules on notice. It's a 60-day notice requirement. There can be preemption. The state or federal government can preempt a case, which is more of an issue, a significant issue for non-governmental entities that are pursuing these cases. And in some, depending upon the statute, there may be a requirement that the violation be continuing, or you have a good faith allegation of continuing violation on the day of the filing. The remedies are generally higher penalties than state penalties. For example, the Federal Clean Air Act, now the penalty is approximate, I think it's over $100,000 per day per violation. And obviously compliance, penalties, and costs, including attorney fees. And it's this latter provision that has allowed many self-sustaining enforcement programs to crop up in the last decades throughout the country, most often in non-governmental organizations, such as NRDC, Earth Justice had some, state organizations do as well. In Massachusetts, the Conservation Law Foundation has had an enforcement program. They're either self-sustaining programs or they're integrated into the organization's program as a whole. The attorney fees can be recovered at market rate, which, you know, if you're practicing in Boston, for example, that can be in the hundreds of dollars per hour. High hundreds of thousands, hundreds of dollars per hour. So the recoveries, while the statute says that attorney fees and costs can go to the prevailing party, courts have interpreted that to mean the prevailing plaintiff, unless the defendant can show that the case is frivolous. So my own experience is that I came up through the NGOs and have done citizen suit enforcement in various different configurations and started different programs in different organizations, from within the organization, from a law firm, and as a solo practitioner. And at in 2017, I was a solo practitioner with a successful citizen suit enforcement program when the election happened, and at which point I thought it was a good time to think about being part of a team, both because I was concerned about the uncertainty, whether the program and the model was going to survive, given at the time how much power the Republican Party had, and knowing that there may not be an affinity for this type of model. And also because I knew that down the road there would be a need for strategic and concerted efforts to address what was going to be a tough time for environmental law from a plaintiff side perspective. So I decided to talk with the people at the Attorney General's office. I had worked there before, my colleagues, and I spoke with my colleagues there, Christophe Corchain, who's the chief, and Betsy Harper, who's the deputy chief. And to their credit, they asked me to do the same thing that I had been doing as a solo and for those many years on behalf of NGOs, but asked me to do it on behalf of the Commonwealth of Massachusetts. And it wasn't what I had originally thought I'd be doing, but I've come to realize that it is actually a great idea, and it has worked very well. And I have come to realize that these types of programs there's no better home for them than in attorneys general offices. So also, I also want to say that the center made it possible through the grant for me to go there and start this work. And also I admired the work of Maura Healy and her team at the time. So that was a big incentive to go back there. So I want to talk about why I think that doing citizen enforcement of federal environmental laws is such a good idea for these offices. It's good for case success, and it's also good for the offices. For case success, I've learned that there's a very big difference in the reaction that one gets when one initiates a lawsuit to enforce environmental laws on behalf of the Commonwealth from the Attorney General's office versus from an environmental organization. There's a cultural recognition that these offices are going to be doing this type of work. And that recognition is held by the defendants, and it's also held by the courts. So that the learning curve, oftentimes when you send a letter on behalf of an NGO, there's a learning curve on behalf of the defendant where they're like, who are these people and why can they enforce the law? That is not present coming from our office. The second reason is that you can bring pendent state claims in these federal cases. That allows you to both ensure that if you run into problems with your federal claims, you still have state claims that will survive. And also, you may have to leave federal court and go to state court, but you still have state claims. And also, it allows you to have a much more robust and comprehensive remedy through settlement, or we haven't had to go to court yet, but through a court judgment. One extremely important factor is that standing is not an obstacle, not the kind of obstacle that you encounter on behalf of NGOs, because you're representing the Commonwealth that has an interest in protecting all of the resources within the state boundaries. So that whole area of law that many NGOs spend a lot of time fighting about is just not an issue. Finally, you have the potential to collaborate with state agencies, and there are terrific experts at the state agencies. The majority of our cases are brought independently without the state agencies, but there is the opportunity for collaboration. These are self-initiated cases, in case I didn't mention that. The flip side is that these cases are good for the office. It allows a level of autonomy and self-direction versus a reactive mode where you get the case from the agency. And this can be especially important when there are different agendas within the agency versus the AG's office. Not something I'm saying we have in Massachusetts, but it does allow the office to pursue the types of cases that are deemed important. For example, in our office, Attorney General Healy has identified racial justice as an important priority going forward, and we have the opportunity to use these tools to identify and prosecute cases that will move that agenda forward. So we have been successful in building the program for approximately 2 years, and we pursue primarily cases that are essentially tried and true enforcement cases. And for us, that has been stormwater. That's the bulk, the skeleton of our enforcement work. But we also have been pursuing more innovative and newer, innovative, and a little less tried and true enforcement cases under the Federal Clean Air Act. There are opportunities to do that under the Federal Clean Water Act as well as other statutes. But for us, the tried and true cases are the federal stormwater cases. The new innovative cases are the clean air cases. And our success, I think, has to do with an appropriate balance of those two. You don't want to get overextended in areas that may end up sucking up all of your time, so that you can continue to be creative, but yet support the program. So thus far, our foundation has been Clean Water Act. The Federal Clean Water Act prohibits the discharge of pollution from a point source without a permit, and that applies to industrial stormwater as well as several other types of water pollution. Emily has been working on stormwater cases and is going to talk to you a bit about our methodology in doing those cases. And then we'll come back to me and I'll talk a little bit about the more innovative Clean Air Act cases that we've been pursuing as well. I should say we've been successful in both areas, but we have been careful in making sure we don't get too invested in the innovative cases to the expense of the program. So I'll turn it over to Emily. Thank you.
Thanks, Nora. Okay. How is that working? Good? Can you see it? Okay. So as Nora said, stormwater cases are really the foundation of our program right now. So I'm going to take some time and sort of walk through our process and some of the tools and strategies that we have been using in bringing stormwater cases. We rely on entirely publicly available information. So all of our cases, as Nora mentioned, are self-directed. We're choosing our own cases. We don't have any information coming from agencies. So we use this publicly available information, and we do a lot of our own research on both finding cases and doing all of that factual research. So this picture highlights why stormwater cases are such a large part of our program. Massachusetts is a very wet state. As you can see, this is the wetland change map from the Massachusetts Department of Environmental Protection. We have a lot of interconnected wetlands and waterways. We use this map when we find facilities. It is helpful in determining which body of water a facility might be discharging into and whether these receiving waters are jurisdictional waters that are protected. Another tool that we use frequently is Google Earth Pro. So this is a computer application, and we use this for finding cases. This picture on the left, we look for scars on the earth, like this one is a mineral mining facility that's next to the Housatonic River. We can also look for specific industries that have unique equipment or facilities that might be visible from aerial imagery. Once we find a facility that we might be interested in and that we think might be discharging or violating the act, we take a closer look at the facility, also using Google Earth. So it's a little tricky to see on this picture without it moving, but when you're on the app, if you exaggerate the elevation, you can kind of see, hopefully you can see my mouse, that it slopes down here towards the river. And when you're on the app, you can move it around and kind of get an idea of how the elevation is changing, and where water might be flowing downhill on the facility. You can also hover your mouse on the facility, on the map, and down here at the bottom, it will tell you the elevation. So as you move your cursor around the facility, you can understand where water might be flowing. We also look for evidence of
I think Emily may be frozen.
Am I back?
Yes, you're back.
Okay. Did I cut off?
Oh.
Am I on now? Okay.
Emily, I would say turn off your video.
Turn off my, okay. Let's see. Okay, can you hear me all right?
Yes.
Okay, maybe that will be helpful. So using historical data, we can look at how a facility has changed over time. That's helpful to know when violations may have started. So this is another facility that we were looking at, another mineral mining facility. So we're interested in this particular site, whether sediment has been existing on this road and the status of this detention basin, things like that. So when we look through time, we can see, okay, in 2015, the facility was operational, and take a closer look at what was going on. 2014, they're developing the facility. 2013, this was still an undisturbed hillside, basically. So we use that tool a lot for finding facilities and trying to figure out what's going on at these facilities. Another tool that we use that is very similar to Google Earth, but different enough that I think it's worth noting the distinction since we use them so regularly, is Google Maps. So Google Earth is a computer application and Google Maps is a website. And on Google Earth, you cannot zoom in on Street View. And this is a really helpful tool for figuring out what's going on at a facility. If it's on a public facing road, you can zoom in. For example, here you can zoom in, you can see where the catch basins are, where stormwater might be leaving a facility, things like that. Some other tools that we use are EPA permitting data. So in combination with researching the physical facility, we use EPA permitting data to determine what kind of violations are ongoing. So first, if a facility seems like it's discharging into a protected waterway, but it doesn't have a permit, then that can be one type of Clean Water Act violation. Also, if a facility has a permit, but they're not listing all of the areas on the facility where water is discharging from the facility into a water of the United States, and they're not monitoring and controlling from these discharge locations, then that's a violation. The facility that I showed you from above on Google Earth, that was a facility that had a permit, but it was not listing the area where stormwater was going down that bank and discharging sediment. So that's a violation because that outfall was not listed. And finally, another type of violation that we're looking for is permitting or monitoring, violations. So either a facility is not monitoring at all and they should be, or if a facility is continuously monitoring over benchmark and not taking any type of corrective action to fix that over benchmark monitoring, then that's also a violation. So the final tools we use are for determining who owns and operates facilities. We use the Massachusetts property map to find out property boundaries, where the facility ends and starts, and who owns the facility. And this is information that can be further confirmed by local registry of deeds websites. And finally, we're using MANTA and the Secretary of State. MANTA is an extensive corporate database. We use it for preliminary information about annual revenue estimates and standard industry classification codes, or SIC codes. And these codes are really important to know because the stormwater permit only covers certain industries, and those industries are classified with SIC codes. And the permit also places certain requirements such as monitoring or best management practices on certain SIC codes. Secretary of State website we use for official corporation names, addresses, registered agents, things like that, figuring out who we're going to send the notice letter to. So once we've done all of this preliminary research and used all of these publicly facing tools, and where we think that there's a violation occurring, we do a site visit to the facility. We do these site visits only from public land, so we're not doing any type of trespassing. This is the facility that I showed above on Google Maps, so we can see clearly that sediment is moving from the facility into the river. And this is not only a stormwater permit, but this was also a Massachusetts Wetlands Act violation, so there was a pending state claim in this case as well. And when we do these site visits, we usually bring either a consultant who is a hydrology or stormwater expert to help us figure out what's going on, or sometimes an office investigator. And that way we have a third party witness with us who can serve as a witness in court. So after we do the site visit, we have all of our information from the site visit and all of our research, and we compile all of that information together. And our office writes the notice letter and the complaint all at once, and we send those up through our office for approval together. And as Nora noticed, as Nora mentioned, the notice letters are extremely important. So most of the citizen suit provisions require a 60-day notice letter to go to potential defendants, EPA, as well as state agencies. And the regulations lay out specifically the content requirements and the form requirements for these notice letters, and they have to be strictly followed to be able to file. So over the last 2 years, our program has sent out 10 notice letters, and these have been almost all exclusively stormwater cases, or at least have all had a stormwater component. And of those 10 notice letters, we have settled 4 cases. We're close to settlement in 3 cases. We're in the process of negotiating 3 cases, and we have 5 cases that we're moving forward internally. And these cases are all settling, and they're settling between 10 or 11 months between when we send our first notice letter to when the final consent decree is entered. And just for some numbers for what our program has accomplished, we're hopeful that by the end of the summer, we will have provided through our suits almost $300,000 to third parties for projects to benefit water and air quality in the vicinity of where these discharges are occurring. $87,000 to Massachusetts for pending state claims, and by the end of the summer, hopefully over $230,000 in costs and fees to our office. And as Nora mentioned, I only joined the office in March, so we're hopeful now that we have 2 attorneys working on this program that we'll be able to increase the number of cases that we're bringing each year. So I hope that I've provided an overview of our processes and the tools that we're utilizing in bringing these cases and highlighting some of the successes of our program. I am going to turn it back over to Nora, and she is going to talk about some important things to keep in mind when establishing this type of program and some of the more novel Clean Air Act cases that we're working on.
So yeah, I'm just going to start with the slide. There are many, many ways to find cases. And of the cases that we've done so far, 3 of them, the notice letters that we've sent out, 3 of them have had Clean Air Act counts. And actually the Clean Air Act count was the dominant count in all 3 of those. The way in which you find cases is always a combination of 3 things. It can be a tip, but it will also include a review of publicly available information and visual observation. And this is a case that began with visual observation. I was talking to a colleague from his window office at the AG's office, and I was looking at the window and I saw this. And this is Boston Sand and Gravel, which is a rather iconic facility in Boston. And that, I was thinking, what is that? So it happened to be a nice day and I had a bike, so I biked down to the facility, and I don't know how to switch the slide. Does somebody else do that for me? Yes, so I saw that it was extremely close. This is a picture from the globe, but this shows Boston Sand and Gravel, very close to recreational facilities, including a skateboard park with a lot of young people. And so I also observed that there were stormwater violations in addition to the clean air incident that I had observed. So we decided that we would watch and see whether that incident was an anomaly or it was something that was happening on a chronic basis. And we set up a video camera in one of our offices and watched it. And I watched a lot of videos over several months and determined that no, this was not an anomaly. And you can actually see from one of these photos that there is a bag house that's malfunctioning. And so after we had amassed enough of this type of data, we sent a 60-day notice of intent to sue to the company. And we were able to obtain a very good resolution where they installed all sorts of good technology and made some payments to the Charles River Conservancy, as well as the state treasury for the state because we had state and federal violations in this case. So that's one example of a way to find cases. The other way is to look at publicly available information, such as the TRI database. Before I talk about that, let me talk about another visual observation strategy, bus idling. If you want to you can enforce through the Federal Clean Air Act SIP provisions, State Implementation Plan provisions. These are provisions of state law and regulations that have been incorporated into the Federal State Implementation Plan. And that incorporation renders them federally enforceable. This Boston Sand and Gravel involved SIP enforcement, and we are now looking at idling cases that involve SIP enforcement. EPA has brought SIP enforcement cases in Massachusetts against bus companies, and so we're going to be doing that as well. So the idling cases, you also need visual observations. We've hired outside investigators to do that. You can use inside investigators, outside investigators. You gather up your visible data and then you can proceed. The other way, we also have been pursuing enforcement against companies that are violating Section 112R of the Federal Clean Air Act. That is the requirement for risk management planning for companies using above or storing, having on site above a certain threshold of acutely hazardous chemicals. That triggers risk management planning and documents, etc., communication with local authorities. One way to identify those cases is to use the TRI database and compare thresholds. A lot of this type of work involves comparing lists of data and seeing where you find the gaps or the things that don't add up, and then pursuing those further. So 112R cases are like that. Okay, so things to keep in mind if you, can we get this slide off of the, can we go to the next slide? Oh, okay, thanks. Thank you. Things to keep in mind in bringing these types of cases. So in Massachusetts, we're one of the few states that has not been delegated responsibility to administer the Federal Clean Air Act. That does not mean that we are, even if you're a delegated state, you can still enforce the state permits that are administering federal law in many cases. So for example, if you have a state NIPTES permit, that's federally enforceable. Clean Air Act, as I mentioned, the SIP provision is federally enforceable. There are other things as well that are federally enforceable. So one of my favorite types of cases is the agency referred hybrid. It's a little bit tricky to get those because this is an innovative approach to enforcement. There is some institutional reluctance to file state claims as pendent state claims in federal court. But if you can look at the cases that are coming from the agency and see whether there's a federal claim that could be brought, and if your relationship with the agency is such that they will, that cooperate with you if you're bringing that case in federal court with the state claims as pendant, those are, to me, the best of all possible worlds, because you get the comprehensive approach, you get the increased penalties, you get a terrific client expert with that will, that's just a very good relationship to have. The downside of that is that the agency may not be on the same timeline as you are, so those cases may take a little bit longer, but it depends on the agency. Another thing to keep in mind is that these types of self-initiated cases, the facts that you will have when you initiate the case with the 60-day notice of intent to sue, and possibly even when you file your complaint, will not be as detailed and extensive as the referred cases. Because except for those AGs who are fortunate enough to have inspection authority, which we don't have in Massachusetts for environmental cases, you are relying, as I said, on the publicly available info and visual observations. So in many of our cases, we can see certain things and verify them and ground truth them, and they're sufficient to bring our case, but we know there's more going on at that site. And so once the notice is provided, we will settle our cases only after we have a site inspection. And so we can really get a handle on what's going on. And what we say to the companies, which is true, is that if we were to litigate these cases, we would be entitled to discovery. And that discovery would include a site inspection, and we would find this stuff out anyway. So we will encourage them to do a more global resolution, not necessarily global with respect to all environmental laws, but for example, with water, if we see that there are other water-related violations going on that also involve pendent state claims, we would perhaps include all of those claims in our settlement. There can be a little bit of discomfort with going forward with fewer facts than you would have with a referred case, but that's the way that NGOs do it, and it's worked out really well for us within the program at the AG's office. Not finally, but almost finally, it's important to maintain a good relationship with the feds and with your state agency on these cases. Keep them informed, nurture that relationship, play by the rules. There are rules that are established in these statutes. You have to provide notice. The Justice Department gets a chance to comment on the proposed settlements. We settle all our cases through consent decrees. We don't have out-of-court settlements. That's for the federal program. And make sure that if some of the penalty money can be paid to a third party for a project that benefits the water or the resource that's at issue, make sure there's a sufficient nexus, because that's what the Justice Department will be looking at. And so with EPA in Region 1, I always run I tell them before we go forward what we're looking at, so that if they're already working on it, we don't want to step on their toes. We don't want them stepping on our toes. So it's important to maintain that collaborative approach. I will say something about experts. We rely on experts. And for those of you without if you're not going to get a referred case and have the agency expertise at your disposal and you don't have in-house experts, you're going to have to hire experts, and they are not cheap. So it's important to closely manage those contracts, to be very diligent about the assignments that you give them, so that that expense line doesn't get out of control. So I think we've learned a lot about how to both find cases and how to manage the docket and how to grow the program, and we're eager to share that with you at this point. So we expect that the program will continue to grow. We're excited to have Emily joining us. So now we have 2 attorneys, and she's been really great right out of the gate. And so we hope to make ourselves available to provide you with additional information going forward. Thank you.
Great, thank you, Nora and Emily, for that wealth of information. It was certainly helpful to me to get an understanding of the program. We have a couple of good questions that have come in, both in the Q&A box and otherwise. And as they were coming in, it's possible you touched on some of the answers to them, but I want to just give you a sense of what folks are interested in. You talked a little bit about, how maybe the ideal case is one that's referred from one of your agencies, but before you send a notice letter, do you try and coordinate with whatever state agency office is involved to see if they have any enforcement action already pending or if they're working with the facility on compliance?
Yes, absolutely. I mean, we would love to have them come on, and they have come on 2 of our cases so far, and it's been really great. Mm-hmm. And if they're doing something, we will not interfere with their efforts.
Great. And then I guess from a kind of structural perspective, you talked a lot about, the work that Emily does and the other attorney in your office to try and gather information. Can you give a little bit more sense of kind of how you document that information? Do you send Emily out with a camera? Are you, and sort of, I guess, have you had to budget, or how have you budgeted for that type of expense, I guess, ahead of time?
Both Emily and I have been outside with cameras before. Yes. So generally what I'll do is because it's expensive to get an outside consultant to go out and do that kind of work, we will often do it ourselves first. And, sometimes it's good to, there's a lot to tell you about how to do it. But it's good to bunch things together. So, we'll spend a lot of time in the office doing a review of certain geographic area. We'll identify maybe 5 sites we want to check out. And then we'll spend a day out in the field, or maybe 2 days, and we will see which ones deserve more of documentation. We usually don't, we will usually rely on a second investigator to come back out, but we want to not have them be doing the initial investigation, because that's not a good use of our resources.
Gotcha. And then you had mentioned site inspections and that you wouldn't be entertaining settlement, I think is what you said, without doing a site inspection. So who's doing those inspections? Is that you, or do you do those with the state agency involved? Oh,
if the state agency is working with us, they will be coming to the site visit. The state agency has been not involved in 80% of these cases so far. So it's us, and if, I've been doing this a while now, so I kind of know what to look for, but I would say that any new lawyers starting out would want to bring a consultant with them who has expertise in identifying where water goes when it rains. That's the most important thing to figure out when you're out on the field. And then you also want to, so there are 2 levels of expertise. There's where does water go when it rains, and then there's also, are these best management practices, stormwater control measures, air pollution control measures, are they state of the art? Can they be better? Can they be improved upon? Are they likely to yield pollution? Are they likely to do the trick? That's a second level of expertise. So you might need 2 experts, but again, you want to try to do everything you can yourself before bringing the experts on.
Mm-hmm. And we have another question here about, you mentioned enforcement cases under section 112R. Can you describe one of those? And was that for failing to file a risk management plan or some other violation?
Yes, yes, I can. That is a case involving a chemical manufacturing facility in an environmental justice community near Boston. And they used I'll tell you a little bit about this case. They used above the threshold of an acutely hazardous material. We sent them a 60-day notice of intent to sue for failure to, we found that out looking at tier 2s. And then we sent them a 60-day notice letter, and then they wrote back and said, oh, no, that's all wrong. Our numbers, we really never use above the threshold. And there's new tier 2s. They sent us new tier 2s that were just like this much below the threshold. And so we asked for documentation, and they sent us a spreadsheet that showed they were above. So that case is going forward.
Gotcha.
We're in discussions with them.
Somebody here just asked for a clarification about tier 2. I'm assuming that's the thresholds of how much of a certain substance you can use.
Yeah. Oh, sorry. And so tier 2s are right to know documents. There's another law that also has a citizenship provision in it called the Emergency Planning and Community Right to Know Act. And that requires submission to EPA of documents related that show how much you have on site. Certain tier 2s are how much you have on site, and then Form Rs are documents related to releases of hazardous chemicals. So both of those EPCRA right to know documents can be accessed by the public and used to identify, companies that are using certain chemicals.
Right. So we have another question here that actually dovetails with something that I was thinking about as you were giving your presentation. You mentioned settlements and DOJ overview. For Clean Air Act settlements, DOJ is now taking the position that mitigation projects obtained under citizen suits are limited to $100,000. Have you had to deal with that constraint yet? And if not, any thoughts on how to do so? And certainly the DOJ's current views on the use of SEPs has gotten a lot of attention. And so I guess if you had any comments on that question specifically, or just generally, if you've run into any issues with that yet.
So far, no. I mean, our settlements have had under 100,000 going to nonprofits for projects so far. And whether we are going to want to fight DOJ about that we'll see. We'll see. And also we're going to have to talk with them and see how far we can go, because there may come a time when, if we go to court and we have a consent decree, that we recommend that a certain amount of money go to a third party. Justice and EPA have a right to comment on that, but it's really going to be up to the judge to make the decision. And we'll have to evaluate that as we go forward. I do expect that this will come up.
Right. And I guess some other questions related to federal activities. What kind of impact has Waters of the United States rule had on your programs?
We're very careful in our selection, and I think that's very important if I haven't already said that. I don't think I did. It's important to be extremely careful in your case selection process and try to make every case as bulletproof as it can be. And remember, we're talking only about a few violations. It doesn't have to be a huge number of violations. It can be a few, but they should be bulletproof. And that's why we've had such success with settlement, I think. So when we select our cases, we make sure that we have an overland connection to a navigable water that we can trace using the wetlands map. And if we need to, we'll go ground truth it. I will say that that the Waters of the United States rule may make the number of, I don't think we would have had to do the overland connection analysis as closely now, before, as we have to do now. You could tell from that map, we have so many wetlands and waterways in Massachusetts that there are still tons of cases out there, many cases. I think it has reduced the number of cases that we could bring because of the more stringent jurisdictional requirements, but we have plenty to do.
And I guess on that note, you talked a lot about stormwater cases, is that being the bulk of a lot of your work. What other types of Clean Water Act cases are you bringing or thinking of bringing?
So in Massachusetts, we don't have a lot of direct discharge into waters of the United States. In other states, do. So for example, Pennsylvania has a lot of direct discharge. So many of our cases, the companies discharge to a sewage treatment plant. There are other types of cases that could be brought include companies that violate the requirements applicable to discharge to sewage treatment plants. That's more complicated, but doable. And discharges from construction facilities. There's a construction general permit. Those cases also are very important, have some complications that would make them fall into the more innovative category. And by innovative, I mean a little bit harder, but not impossible. And so the direct discharge, construction, POTW, they're, that's pretty much it. I mean, there's municipal permits as well, but we haven't done those.
Right. And then switching over to air, we have a question here about asking for a little more specifics about what the Clean Air Act case was against I think it's the sand and gravel facility in Boston. Was that a visible emissions case or a violation of an air permit? What were the nature of those violations?
Yeah, that was a Massachusetts regulation governing dust emissions that was incorporated by reference into the state implementation plan. So we brought it as a federal claim and as a pending state claim.
Great. I guess if you could also talk a little bit about what impact our current global pandemic has had on your program, what impact COVID has had. I assume it's had some on your ability to get out and look at facilities, but if you could talk a little bit about that.
We still seem quite busy. So we have retained an expert who will help us if a company claims that they are having financial difficulty and they want to invoke the ability to pay defense to a penalty proposal, then we have been anticipating that that's going to come up. It has come up less than we had anticipated. So our expert is not getting a lot of work right now from us on that point. So the cases seem to be resolving. We do have to be careful in the field, although there's definitely ways to be careful. We will continue to evaluate the company's condition as we bring the cases going forward. So, that's a reality for the regulated community, but it doesn't mean that environmental compliance stops. And so, unlike the federal administration, we are moving forward with our enforcement within the office and within the initiative.
Great. That's not me. So maybe one more question, given that we're almost at the top of the hour. I guess if you could talk a little bit about some of the kind of obstacles or common legal issues that you've run up against, things or maybe opine a little bit on where you see the office going in the future, or enforcement trends. I'll leave a little bit of an open-ended question there for you to end with.
Yeah. So for now, we are doing clean air and clean water, but we have talked about, since in our 112R case, EPRA came up as an issue, and we've been talking about expanding into EPRA as well, Emergency Planning and Community Right to Know Act. Legal issues, as I said, we have to be extremely careful in our case selection, so we haven't really run into a lot of legal issues. We've had some not good arguments come our way. Most recently, we got an argument based on the Maui case where the defendant argued that its discharge into an municipal storm drain system was not a discharge into navigable waters that could be covered by the Federal Clean Air Act. Now, we forgot to mention that the federal stormwater permit covers stormwater discharges into navigable water and also into municipal storm drain systems that discharge into navigable waters. And so somebody said, well, based on Maui, that's not a direct discharge to navigable waters, so you can't bring that case. And so we roundly defeated that argument in our response to that. But so we haven't had a lot of arguing from defendants.
Great. All right, well, I want to just thank Nora and Emily again for joining us today and for giving us a really interesting overview of the work that their office has been doing. Certainly the slide here, as folks can see, provides their email addresses if folks would like to reach out to them directly with any additional questions. This webinar has been recorded, and so it will be available to you if you'd like to review it again or pass it along to all your friends and neighbors. Thank you again to everybody for joining us today. And with that, we will say goodbye.
Thank you.